Of Surendra Krishna Roy versus Mirza Muhammad Sayyid Ali, 63 IA 85, it was held that this section lays down that a notice must be given before secondary evidence can be received under section 65A. Notice to produce a document must be in writing. Order 11, Rule 15 of the Code of Civil Procedure prescribes the kind of notice to produce in document. Notice is required in order to give the opposite party a sufficient opportunity to produce the document and thereby to secure the best evidence of its content. In a case of Dinanath Rai versus Rama Rai, 1926, 6 Patna 102, it was held that such notice may be dispensed with if it is not necessary or pleading or the court thinks fit to dispense with it. Such notice may be dispensed with if it is not necessary on the pleading or the court thinks fit to dispense with it. Secondary evidence of the content means apparently not of the existence or conditions of the document. The word party means only adversary in the cause, but also stranger legally bound to produce the document. The proviso enumerated in 6 cases in which notice is not required to be given to the party in whose possession or power the document is, in order to render secondary evidence admissible. Procedure for production of documents in a criminal cases is laid down in section 94 to 98 of the Code of Criminal Procedure. Section 175 of the Indian Penal Code punishes the person who omits to produce a document required by the public servant. Under section 67, proof of signature and handwriting of a person alleged to have signed or written document produced. In a case of Abdul Ali versus Abdur Rushman, 1874, it was held that this section merely requires proof of signature and handwriting of the person alleged to have signed or written the document produced. In a case of Bulkidas versus Sheikh Chotu, 1942, Nagpur 661, it was held that mere admission of execution of a document is not sufficient. Proof that the signature of the executant is it in his own handwriting is necessary. In case of Mr. D and Mrs. S, 1961-68 Bombay Law Report, it was held that where merely the signature of a person to typewritten document was identified the witnesses, it was held that what was formally proved was the signature and not the body of the document. In the case of Ponaswamy Godhan versus Kalyan Sundaram Iyer, 57 Madras 662, it was held that the Evidence Act permits secondary evidence to be given with regard to the attestation of an attesting witnesses. Proved in evidence is a proof of everything on the face of the document, and that he saw the executant and makes his mark. In the case of mark by 60, it was held that beside the questions which arises as to the content of the document, there is always the question when the document is used in evidence. The evidence upon this point is dealt with in a section 67 to 73. The nature of evidence will depend to a large extent on the nature of the document. If it is a mere memorandum, such as the entry in a diary mentioned in section 32b, must be proved that the diary was really that of the person whose statement it is said to contain. If it is a letter, it must be shown who wrote it, or at any time, any rate, who signed it. For a signature to a document turns to the whole document into a statement by the person who signs it. If it is an agreement, it must be shown who executes it. In a case of Rukmanan versus Ajit Saria versus Usha Sales Private Limited, AIR 1991, NOC 108. It was held that in a case of money suit for a good sold on a credit, the plaintiff examined his accountant who prepared the document, such as the ledger, challans, and corresponding bills, but who, in his cross-examination, categorically stated that he did not prepared the document. It was held that the document in a question could not be said to have been proved. In a case of Rajaman Khan versus Baba Raghunath Das, AIR 1992, Madhya Pradesh, page 22. It was held that the document, its content of which were not proved, nor the maker of the document examined, was held to be irrelevant. In a case of document executed by thumb impression of an illiterate person, the party putting forth the document has to prove that the document was read over and explained to the executant. In a case of Bhagwanji Hoshbam versus Devji Punja, it was held that the execution means signing, sealing, and delivery of the document. The term may be defined as formal completion of a deed. It is the last act or a series of acts which contemplates it. Case of Salimatul Fatima alias, it was held that mere registration of a document is not in itself sufficient proof of its execution. In a case of Khushiram versus Findi, AIR 2003, Himachal Pradesh, page 23, it was held that where a mere photostatic copy of a registered sale deed was placed on a record, it was held that the mere proof of a registration was not the proof of the due execution. Where there is a failure to produce the original sale deed or its certified copy of the non-examination of the attesting witnesses or scribe of the document, it would have to be held that the execution of the document was not proved. In a case of Prem Raj versus Misrimal, it was held that mere production of registered deed is not sufficient to prove the identity of the executant established by oral evidence before the deed can be taken to have been proved. In a case of Chandrabati versus Lakshmi Devi, AIR 1991, Orissa, page 289, it was held that in a case of a will, the burden lies upon the propounder to prove its genuineness. The deceased testator being no longer available to speak to its genuineness. Accordingly, where the evidence produced by him was contradicting his claim, and there was also inconsistency in the opinion of the handwriting expert, the will was held to be not proved. In a case of Abdullah Paru versus Ganibai, 11 Bombay 690, 1887. It was held that the deed of conveyance was tendered in evidence in which purported to be bear the mark G as a vendor and which was duly attested by 4 witnesses. G, however, denied that she had ever executed a deed and said that the mark was not her. All the attesting witnesses were dead. A witness was called who knew the handwriting of one of the attesting witnesses and who swore that signature of that witness to the attestation clause of the deed was genuine. It was held that the deed was admissible in evidence, its execution by G being sufficiently proved. In a case of Bank of India versus Alibai Mohammed, AIR 2008, Bombay 81, it was held that the suit for recovery of a loan amount was filed by the bank. A demand notice was sent by an advocate. The photocopy of demand notice, which was filed and carried no signature of the advocate who was supposed to have issued it. Nobody proved the content of the demand notice. There was no evidence showing dispatch or a receipt of the notice. The notice was held to be not admissible as legal evidence. In a case of A. Tajuddin versus Union of India, it was held that merely because the merger, a recovery memo executed at the time of recovery was attested by 2 independent witnesses, that would not lend credibility to the same. Such credibility would attach to it only if the said 2 independent witnesses are produced as a witnesses and the accused is afforded an opportunity to cross-examine them, which was not done in the instant case. In the case of Mudasani Savojana versus Mudasami Narsaya, AIR 2007, AP 5050, it was held that Section 67 mandates that the signature and handwriting of a person on a written document can be proved only by examining the person concerned. When the person is very much available and alive, an attempt to prove his signature and handwriting by examining a third person as a witness would have its own drawback. An inference of the type indicated in a section 114 would become applicable.